Please be seated. Good morning. Today is November 4th, and this is the time set for oral argument in CV25 0176, Parker Law versus CEC. Out of respect for counsel, I would request that everyone in the courtroom make sure your cell phone is on silent. Each side is allotted 20 minutes for argument, although you're not required to use your time. Mr. Abney, if you wish to reserve a portion of your time, it's up to you to do so because the clock on the podium reflects your total remaining minutes. These proceedings are being live streamed and will be available on our website for viewing. With that in mind, please speak into the microphone when presenting your case and identify the client for whom you represent. We've read the briefs, studied the record, discussed the case in conference this morning. And with that, Mr. Abney, you may begin.
May it please the court. My name is David Abney. I'm here to represent the defendant appellant. As always, it's an honor and a pleasure. Sometimes it actually works. In preparation today, by accident, I was reading book 22 of the Iliad. This is the one where Achilles gets a new set of armor. His friend's been killed, and he attacks the Trojan armor so disastrously that they flee inside the city and shut the gates, leaving Hector outside to fight Achilles. And Hector turns to Achilles after Achilles chased him 3 times around the city. Hector gives up and says, well, I will fight you. I know you're the better man. I know you're going to win. I know my city's going to fall. I also know that you're going to be killed by my brother Paris before the city falls. And he says, but maybe, just maybe, Zeus will say, I'm going to change things. Of course, it didn't happen. But in this case, maybe, in the position of Zeus, the court will change things. Panzino,
We've been called a lot, but Zeus is not one of them.
Well, from my perspective, it's not Olympus, but it's close. Interesting book. It's fascinating. So much goes on. And then, of course, the Odyssey is even more interesting, I think. But be that as it may, the big problem here is Panzino. It says that we did away with the complete abandonment rule and that you can have the world's worst attorney who stops working for you, just lets your case go to rack and ruin, and you're stuck with it.
Well, you have a remedy.
Well, the remedy is legal malpractice.
To sue your lawyer.
Yes, but it's not really the same. And malpractice policies can vary from $100,000 on up, or maybe even less. And it's not the same as actually winning your case by any means. It's a sort of like kissing your sister, if you're part of the analogy. Not very satisfying. But Panzino, I don't think addressed this particular situation. I don't think other cases have addressed this particular situation, where the attorney not only abandons the client, but also is lying to the client, is assuring the client over and over that things are going along just fine. And the client here said, that's what I was hearing. I did get some materials from the court. I asked my attorney about it, and the attorney said, everything's going to be fine. We're going to fix it all. I think that takes this outside of Panzino.
But it's not just one notice. I mean, the client's getting noticed on a string of
He did.
orders. So at some point, don't we have some responsibility? Can't we place some responsibility on the client to be paying attention?
I don't know. Precedent says, I'd say yes, but precedent says that you're supposed to be able to trust your lawyer and act upon that fundamental principle.
This isn't a situation where it's the first time the client has been involved in litigation. It's actually litigation over payment of fees for previous litigation. So it seems unusual to think that a client would think, oh, I've hired an attorney. I don't have to do anything until I hear how did my lawsuit end? I mean, they know that there are things that happen along the way, and it seems seems unusual to think that a client would just defer everything to a lawyer and not be at all concerned given the orders that are coming out of the court.
It's a difficult point, but then again, there's no contrary evidence to say that the client did anything other than trust this particular lawyer.
Well, he was concerned. He went to the lawyer and said, what's going on with
Yeah,
my
and then the
case?
lawyer reassured him, and so everything was fine at that point.
And then he continued to still get notices.
Yeah.
And
But you also have that month gone where the lawyer is suspended by the state bar, and he can't be doing anything at all for the client. And it's a crucial month. There's a lot that goes on in that month. There's a due date for the response to the motion for summary judgment. There's notices filed concerning the disposition of the case, an application for fees, a lodging of a proposed judgment, and then the trial court files its case-ending ruling, all within that month. There's a lot that could have been done by the lawyer, but there's no lawyer there at all. Now, how is the client then liable in that situation? Does the complete abandonment rule, I submit, doesn't apply here? The client has been left completely defenseless, and it should be something to consider in what do you do to should you set aside the default? Well, why not? When you have been not only abandoned, but you don't even have a lawyer anymore.
But if we agree it's something you should consider, I mean, do you also, I mean, is there some discretion on the part of the trial court to consider that and say, yeah, that's a very strong factor in the client's favor, but the client has some obligation? I mean, is there any discretion that the trial court has to say the client is not without some fault here as well?
In circumstances like these, strange circumstances like these, I would say no. Once you know there is this 1 month carve out, you need to do something. Set it aside and let the client hire a competent lawyer, which they did, and the competent lawyers tried as hard as they could to rescue the situation, and it just didn't work.
Mr. Abney, let me ask, you're right, there was that 30-day window when Mr. Goldman is suspended. He's later disbarred, right?
But afterwards, yeah.
Yeah, but in looking at that 30-day window, it's just after that. On the 20th of October, the court issues a minute entry sort of noting his suspension, recounting the procedural history of the case. And the very next entry, a couple days later, is the minute entry where the court endorses CEC and has a link to that prior minute entry saying, hey, here's the procedural history, your lawyer's suspended. Is there nothing to be made of that? I mean, it strikes me. And then the court waits another 60 days or so before entering the judgment. This is not a trial judge that's rushing to judgment. Now, I get it's a judgment that your client is not wild about, understandably, but it seems to me that the court did a lot of work to turn procedural square corners. And what are we to make of that on appeal?
On appeal, we are to make we are to make of it that more should have been done for the client under these unusual circumstances. When you've got this missing month, you've got the lawyer lying to the client consistently, the client being aware there's some problems and seeking counsel from the lawyer he hired to protect him, to protect the interests of the company, and getting consistently everything's fine. It's an unusual situation. Why not set aside the default? Get new lawyers in there who are competent. I mean, the original lawyer admitted he was incompetent, that he did badly, and he did.
Well,
but
and
why not reboot the case?
I guess too, there's a judgment that's entered in December that CEC is endorsed on, and they wait until late June of the next year to file anything?
Well, and I think
they know that's knew or should have known that's a bad outcome when the judgment's against them, and they wait 7 months.
Well, you need to, what is it, a reasonable amount of time to bring the Rule 60 motion?
And this one I think is a little bit beyond 6 months. I shouldn't say beyond a reasonable amount of time.
Well, we're pushing the envelope, to put it mildly. But then again, you need to get the new lawyer in place, get the new lawyer up to speed. New lawyer needs to evaluate the case, and the new lawyer needs to act. Should it have been done sooner? We can always do things sooner. This case is a prime example of lots of things that
Yeah.
should have been sooner.
Yeah.
All I can do is plead to the court that this is a reasonable amount of time given the unusual circumstances of the case.
And on our review, though, we review that decision for an abuse of discretion, right?
Yes, Your Honor. You do. I'd like to change that to de novo.
No,
but
I
it's
understand. I understand. I'm not thinking that's going to happen in this
No,
case.
I don't think so either. But I must try, like Hector on the battlefield, to do my best.
Understand.
Wait, can we go back to, you were saying this, you think it's different than abandonment. But I struggle with that because I think abandonment is all-encompassing. And I'm not sure is there a particular definition of abandonment or something that would indicate this seems to be a type of abandonment?
Well, if there were
A
a definition,
subset of it, anyway.
I'm sure there's a definition of abandonment. If there is, it should have footnote this case. I mean, this is abandonment, certainly, but this is abandonment plus assuring the client that there's nothing wrong, everything's going fine, plus that 30-day window when the lawyer couldn't do anything at all.
But
And of course, didn't tell the client about that
But
either.
that's not the test that was given to us, was it?
No, well, Penzino says what do they call that rule? The complete abandonment rule we're not adopting, period. And Justice Feldman had an interesting dissent. He said, we're talking about default. We're talking about, what's the word? Oh, neglect. Excusable neglect under Rule 60B1, and now you're trying to say inexcusable neglect under Rule 60B6, and it's not really neglect at all. This is complete nothing. This is abandonment. This is not neglect at all. Is this abandonment? Sure, this is abandonment, but it's abandonment with additional circumstances that would lift this, I submit, outside of Penzino. And allow.
I just don't see where I guess for me it's the plus, where we read plus into that case.
No, there is no plus in that case.
Well, yeah, I mean, that's why I'm having a hard time.
But it did not say there is no plus. It didn't talk about the client not being informed.
Well,
This is different. This case is the plus.
Total means all-encompassing, doesn't it?
It sure does.
And
Beautiful
so
word.
if it's all-encompassing abandonment, then if we're talking about any type of abandonment, it would be, yep, it's in there. Unless there's some way you can carve it out to say, no, it's not abandonment.
Well, as I say, I prefer the word plus. It's a more positive word. And the plus here is not only this month carve out. You couldn't have that guy as your lawyer, even if you wanted to. And even if he wanted to do something, he couldn't. He was not a lawyer for that month. But it's also assuring the client that everything's fine. There's the plus. And it's not the plus that you find in Penzino. This is the case that offers the plus. I can reserve my time, if I may.
All right,
All right.
counsel, thank you, Mr.
Thank
Edney.
you.
May it please the court, my name is Jonathan DeSaules. I represent the appellee and plaintiff Parker Law Team. There's a strong public policy favoring finality of judgments. Rule 60B gives a safety release valve equitably, and it's not granted liberally. We've talked a lot about the Penzino case this morning. Penzino addresses the very issue that counsel raises, this abandonment plus. If you look at the Penzino case, it says, we assume for purposes of this opinion that Appleton's actions comprised longstanding and pervasive neglect, that he completely abandoned his client, and that Penzino was relatively free from negligence. That was the standard that Penzino set. Now, in this case, I would submit that you may have Penzino plus, but the plus is you actually have the individual himself, the client, not free from negligence in any respects. You have 13 separate court filings that my office mailed to his statutory agent.
What Mr. Abney is suggesting, though, that this is something worse than neglect. Neglect could be someone who just walks off into the sunset and doesn't tell anyone where he went. But here he affirmatively represented, I've got it, everything's under control.
But isn't that the completely abandonment? Isn't that completely abandoned?
But you completely abandoned them, but then you also gave reason so the client wouldn't think they're being abandoned. You're telling them, I've got it under control. That does seem worse than abandonment.
But what facts are in the record to support that? Absolutely none. What the facts are in the record are an affidavit.
He says that the lawyer that Goldman said, I've got it. Everything's under control.
Right, and he did that in the form of an affidavit that he had to change twice materially because the trial court, the finder of fact, said some of these statements seem to be provably false. Not simply incorrect, but provably false. That is a decision that this court has to give substantial deference to with respect to what the trial court found and how the trial court found it. And in that situation, I would submit that you have complete abandonment. If you want to, even if you accept the argument that this attorney daily, weekly said, don't worry about it. First of all, that's not reasonable, and that was a decision that the trial court could make. But that's the client himself, the party, acting neglectfully. He's getting motions to strike. He's getting notices of suspension. This is a sophisticated client who's getting these court filings and also then getting court orders saying your attorney's been suspended. And as Judge Sama pointed out, in October, the court took the step of non-protunct issuing an order specifically endorsing the statutory agent and then waited an additional 60 days before issuing his ruling. That is giving the client the benefit of the doubt. And frankly, at that point, again, if you assume all the facts that the attorney was calling, the attorney was communicating, none of which was submitted, and I would submit to you that Rule 60B requires a record, not simply a bare bones affidavit that you have to change twice because the trial court asked, isn't this a provably false statement here? And they did change that. He went from saying, I had no knowledge at all, to saying, I received every single thing that was filed. All 13 court filings. Even if you assume that was wrong and you call your lawyer, then you have court rulings. And the court is saying, we are striking your answer. You and your lawyer are doing this. The October minute entry and then followed by the judgment in December were very specific, and it called out not simply the lawyer, but the party as well.
Could I ask the October order, the court also advised that setting another hearing would be futile. Does that mitigate in the client's favor, saying, well, there's nothing I can do at this point? The court has said I'm not going to set a hearing, whether the client understands you could have a culprit hearing or some other type of hearing. Why would the court say any further hearings would be futile at that point?
Because the party and his lawyer has completely walked away from the case. That could have been a strategic decision. That happens in cases. Parties say, you know what, this is not worth pursuing. And that's the concern that was in Panzino. That's the concern that is repeated throughout this court's rulings, which is we don't want to give the party who may have made a bad choice, whose case is going down the wrong path, the opportunity to lay the blame completely on his lawyer or her lawyer. The issue here is...
We don't want to give it the opportunity? Why would we want to preclude someone from saying, I have no fault here, here are the facts that show that I was not at fault?
And we didn't see that until June of 2024, more than 8 months after the August filings, more than 6 months to the day after that judgment. Now, Rule 60B talks about a reasonable time. And 60B1, 60B2, and 60B3 say 6 months. When they initially were proceeding, we thought under Rule 60B1 based on the motion and the reply in the underlying case. So now if we're shifting to 60B6 on appeal, the question is what's a reasonable time? And the Marquez case says it's the totality of the facts. You don't just look at a clock. And in this case, the totality of the facts suggests that the party knew, the party watched his case fall apart and did nothing. And that's not reasonable, and that's not why Rule 60B6 exists. Rule 60B6 exists for extraordinary circumstances, and we don't have that here. And unless your honors have any further questions, I have nothing further at this point.
All right, thank you. Mr. Abney, any final word?
Goodbye, so long. Thanks for all the fish. I don't know a good final word to make, but it's been an honor and pleasure. Well, anyway, as final words apart, to return to the Iliad, and there's an instructive point here that's not very far-fetched. Achilles was doing great, destroying the Trojan army, and then there's some facts in the story that are often overlooked. Apollo pretended to be one of the warriors of Troy that Achilles was after and led him astray off to the river so the rest of the Trojan army could get inside. Still, Hector got left outside, but Hector, he raced around the walls 3 times, and then Athena came to him in the disguise of another Trojan warrior and said, "I'm here to help you out, and we'll fight Achilles together." And so Hector said, "Okay, the 2 of us, we can try." And he turned to fight Achilles and then looked to his right, and the warrior had vanished because Athena had led him to his doom. Deception is an important part here. It was an important part in that story. It's an important part here. The client is being deceived, not only being left alone and totally abandoned, but deceived about what happened, and that's something that's different.
But the court was aware of that. The court presumably factored that in.
Yes, but not sufficiently because, well, I think that the court did not appreciate that Penzino did not have that additional factor in it, and that's an additional important factor. And not only that you're abandoned, but your client's lying to you about that consistently over and over, and you're trusting your lawyer. We want our clients to trust us, and
but the court's making a determination about whether to attribute some blame to the client, and presumably the court's listening to this testimony that's very compelling. I'm completely abandoned. I've been misled by my attorney.
mm-hmm.
So the court didn't say that's not admissible. I'm not going to consider that.
No.
For all we know, the court considered it, but nevertheless concluded that the client bears some responsibility, and in this case there was plenty of time to do something, yet did not.
But why not lean in toward having an actual hearing on the merits, proceeding on the merits?
Did they ask for a hearing? Did your client ask for
Well,
a
they
hearing?
asked for a new trial, ultimately, sure. That's a new proceeding.
But for a hearing on how much my attorney was to blame? Or
Culprit hearing?
A culprit
I don't think there was the culprit hearing process that was instigated, other than I don't know if you want to call the judge's ruminations a culprit hearing. I don't think there was a culprit hearing in the case. I don't think one was asked for. But when you get circumstances like this, why not lean toward this is bad. This whole thing is terrible. Let's just have let's start this process over, get rid of the default judgment, and go forward. And when we talk about a reasonable amount of time, whether it's 1 day or 6 months, does that really matter? If there is,
when do we start to measure? Because for me, when I was reviewing this, from the time that the judge sent the minute entry saying, this is what's going on, was it reasonable for your client to continue on with Mr. Goldman? And I don't think it was. I mean, you get a notice from the court that says he's been suspended. This is all of the stuff. He hasn't been going on, etc. And then it was 2 months after that period, wasn't it, Mr. Abney?
Mm-hmm.
Before he entered the judgment. So aren't we really talking about a period of time that extends beyond the simple entry of the judgment?
But by that point, the damage had been done. I mean, everything had gone to rack and ruin in the case, and what needed to be done then was to set aside any sort of default, any sort of adverse action against the client, and to allow this to go forward on the merits.
Except, I read Judge Blarney's minute entry as saying, you better get down here, and you better do something about this. I mean, otherwise there was just no purpose of it. He's putting your client on notice that you need to take care of this. and he doesn't do anything. So 2 months later, he issues the judgment.
Well, there again, he was relying on what he had been told, and
It's also in the context of they'd filed for entry of default, so they already knew, man, something needs to be happening. And it seems like the overall context, and then you get minute entries saying your attorney hasn't complied with what he was supposed to have been doing, and now he's been suspended. It seems like that's a pretty big red flag that would.
but that was after the fact. Any sort of
But it's
information about
before-
suspension was well after the fact of the suspension
no, it's
occurring.
before judgment is entered. It's a couple months before judgment is entered. It seems like that would be a kind of a call to do something expeditiously. But instead, he didn't do anything then and waited another 6 months to seek relief from the judgment.
Well, a lawyer would any time you see that word default, lawyer alarm bells go off, and you do act immediately and as fast as you can. Clients are different. That's why they rely on lawyers to take care of these things for them. And here the client over relied on a lawyer who, and I don't want to say, I don't want to say too much bad about Mr. Goldman. He had terrible problems, and as a result of that, he fell apart. We've all seen it happen to our colleagues. We've seen it happen to some of our colleagues. They burn out. Something happens. They get ill. They just can't take it. And it's sad when it happens. But I don't think the client ought to be punished. When you have time enough to start over, get rid of that default, you've got some good lawyers here. Go forward on the case on the merits, and let's see what we can do about getting some justice done. I mean, that's the business, right? And I have finished with the Iliad and everything else I've got, so thank you very much for your time.
All right. The matter is deemed submitted. We'll issue a decision in due course. Thank you very much for your argument and your briefing.